An explosive case combining politics, identity, and alleged lies came to a dramatic conclusion today. It involves actor Jussie Smollett, star of the hit TV show Empire in the late 2010s. And as the show hit its peak, Smollett said that he was the victim of a racist and homophobic attack in Chicago in 2019. At the time, he claimed that two men wearing MAGA hats targeted him with racist and homophobic slurs. Now, Smollett said that they tied a noose around his neck and yelled out, "This is MAGA country." Now, according to investigators, they believe Smollett staged the entire attack. He was charged, but the Cook County State's attorney reached an agreement to dismiss the case in exchange for community service and a $10,000 bond. Now, that outraged many people in Chicago, and it made its way across the nation as well, with some of the top politicians weighing in. A special prosecutor was brought in to investigate, and Smollett was charged again. He stood trial, and he was convicted in 2022. Now, today, to bring it current, the Supreme Court of Illinois unanimously overturned that very conviction. They ruled that Smollett's trial should have never even happened. They didn't get to the substance of the facts, but because of that initial agreement with the prosecutors. The special prosecutor says today's decision, quote, does not clear Jussie Smollett's name. He is not innocent, unquote. Now, Smollett's lawyer argues the exact opposite.
I must say this. Jussie's back to where he was. He's presumed innocent.
Well, joining me now, Kim Foxx, the Cook County State's attorney behind the initial deal with Smollett. She joins me this evening. Thank you so much for being here. Kim, you called the second criminal case against Smollett at one point mob justice. Do you feel vindicated by the Supreme Court's decision today?
Thank you for having me. I feel like the Supreme Court decision affirms what I learned in my first semester of my first year of law school, which is that you cannot try someone for the same crime twice. And so it's vindicating in that we should never have been here in the first place because we find ourselves back where we were in March of 2019.
You can sum it up by thinking, look, a deal is a deal. And he performed his end of the obligation, the community service, the relinquishment of that bond. That seemed to be the agreement that was made. And yet he was still charged nonetheless after a special prosecutor came in and got involved. Why do you think that special prosecutor truly became involved in this case?
Dan Webb is one of the preeminent prosecutors in this country. He was a former U.S. attorney for the Northern District here. He worked on Iran-Contra. He is a prosecutor who knows the law extremely well. Dan Webb also knew from the very beginning that this would be double jeopardy. I think the cries and demand for justice, if you will, was driven by a desire to get a different outcome. And the law doesn't allow us to do that. And Dan Webb knew that from the very beginning, which is why it's no surprise that a unanimous Illinois Supreme Court said that this was not proper. So I think politics were at play, and Dan Webb was allowed to participate in a political act.
Many people wonder whether he got a sweetheart deal. That was always the phrasing of this. I think, I have been a prosecutor. You and I have talked about this. The idea that prosecutorial discretion sometimes is very offensive to people and the choices people make about the plea agreements they offer. Why did you choose this route as opposed to a more severe punishment?
Well, first and foremost, as you know, Cook County is the second largest county in the country, and we have the second largest prosecutor's office in the country. And we are dealing with every day on the ground here issues of gun violence, sexual assault, domestic violence, very serious cases. What Mr. Smollett was charged with was disorderly conduct. He was charged with filing a false police report. And in cases like that, with someone who doesn't have a criminal background, generally we would offer what we call a diversion program or an alternative prosecution. And this was someone who didn't live in Chicago, who worked here. And so what was offered to him was similar to what we would offer someone else. But he was allowed to do his community service in advance. He forfeited his bond. And that is in line with someone charged with this level of offense. That's what he got. Yeah. He was actually treated like everyone else. The secondary prosecution, where the criminal justice system was upended to go after him again, that was special treatment. And that is beyond what our Constitution allows.
What would be the impact in your office for prosecutors in your county, frankly, across the nation, if this were allowed to stand and a defendant could make a deal, hold up his or her end of the bargain, and then later on, because of public outrage, you could say, never mind, I want something different?
Yeah. It would absolutely upend our criminal justice system. And really, when the Constitution was formed and the 10 amendments were put in, the Fifth Amendment that allows for protections for the accused was at stake here. And at the end of the day, when you make an agreement, and we knew that all along, when you make an agreement and someone fulfills that agreement, that contractual obligation between the two should stand. If we are allowed to have political prosecutions, or as his defense attorney said, persecutions based on mob outrage, then as a prosecutor who took an oath to uphold the Constitution of Illinois and the United States, then there's no place for me. And what happened here, and what is frustrating to me, is that the special prosecutor knew that, the judge who appointed him knew that, and somehow thought that they would escape the ultimate eyes of judgment of the Supreme Court, which found that you cannot do this. This is fundamentally against our constitutional principles.
Now, just to be clear, and many people followed this story from the inception, they want the court to focus on the merits of the underlying allegations that he made. This appellate court did not do that. He's always professed his innocence. Why didn't you have him admit any guilt in the original deal? Why, many people want to know, wasn't that part of it? Was that normal?
We have agreements where people can do conditions without necessarily having to admit guilt. I think at the end of the day, this case was something unlike anything I had ever seen, not just the underlying allegations, but the intense media scrutiny that was involved. We're talking about our courthouses were packed with cameras, packed with reporters. I had child sexual assault victims having to walk around to get to their courtrooms beyond the spectacle. And so I think what was at play here was, how do we ensure that there's some accountability for the action? We can't even make the offer for the agreement if we don't believe that Mr. Smollett was culpable. And so we did that.
So you believe that he was not innocent?
Of this case. No, I mean, ethically, this is a former prosecutor. We can't ask you to perform community service or forfeit your bond if I don't believe that I have the merits to take this case to court. So that was never an issue for us. The indictment that our office issued for Mr. Smollett was the same evidence that was ultimately used against him in the secondary trial. So this case, and allow our resources to go after those who are engaged in violent criminal acts and still have accountability for what happened here.
He maintains his innocence this very day, and there are those who look at the discretion that was exercised, especially in a time when we talk about who is above the law and all of those things. Do you think this case represents justice?
I think this case represents what prosecutorial discretion is all about, which is empowering prosecutors to decide how to use their limited resources to advance for justice in their communities. And at the end of the day, Mr. Smollett and what has happened in the 5 years since, and the millions of dollars of taxpayer money that have gone into a secondary prosecution on a nonviolent, low-level, one step above a misdemeanor case, that is not justice. I believe the people of Cook County who have had to pay for this second prosecution, that again, the special prosecutor knew at the outset was not a proper prosecution, is not justice. I think we find ourselves back where we were in March 2019, and I believe that the disposition of that case, while maybe different than what many would have expected, was proper.
County Attorney Kim Foxx, thank you so much for your views tonight.
Thank you.